Hello, everyone, and welcome. I'm very happy to have Gerry Kane as my guest today. Gerry has devoted over 25 years helping families achieve their goals of protecting their wealth and is dedicated to assisting families with special needs. He has over 3,000 clients and is a certified specialist in estate planning, trust, and probate law. As a parent of a special needs daughter himself, he understands the real world and the financial aspects of caring for a child with special needs. This experience enables him to not only relate to other parents, but to ensure that the plans his clients create consider the real world aspects, including guiding how they live, where they live, selection of caretakers, sporting activities, religious activities, and more. Gerry has served on many boards, including the Dubnoff Center, a pioneer in the area of special education. He has also served on hospital boards and is currently serving on the board in the Southern California National Academy of Elder Law Attorneys. He is an in-demand speaker for bar associations and for many special needs support groups. His book, titled Financial and Legal Planning for a Lifetime of Care and Support of Your Special Child, will be published soon. Welcome, Gerry, and thank you so much for joining me today to discuss the importance of proper financial planning for your loved one with special needs.
Oh, thank you, Gilda, and so excited to be here on this podcast and to help so many families and parents out there get a little bit of guidance and education.
To begin with, tell me, why is helping parents with special needs a passion for you, and what are some of the things that can be accomplished with special needs planning?
Well, that's actually two questions, but I'll answer them in order. The first question, we need to go through a little bit of the history of my family, and why it's such a passion is that, my oldest daughter, she was 5 when she was officially diagnosed with autism. Before that, doctors thought she was bipolar, and, we knew she had some difficulty socializing and making eye contact. She was having all kinds of tantrums, and for those of you that have individuals who have special needs, you know what I'm talking about, and all kinds of behavioral issues. Her teachers told us that she might be autistic, but, I wasn't open to hearing that at the time and refused to accept that I was bringing a child into the world who might have problems. Classic denial. My first wife, she was a lot more accepting of it, and she knew something was off long before that, and she had come to accept it. Our second daughter was born a few years later, and we knew the challenges that laid ahead of us. We knew how challenging it was going to be to parent a child with autism. And, we may have decided that if we had known about those challenges and all the difficulties, that one child might have been enough of a handful, let alone 2 children. And some of the challenges we faced is it caused a lot of stress on our marriage. We were constantly stressed out, and financial stress, and my wife, she passed away, and I did remarry 9 years ago. And while I was married with my first wife, we wanted to assist my daughter and, provide her the best ability and how to get, assistance with so many services that were needed, because she was, needing sensory integration, IEPs and IPPs and physical therapy and behavioral therapy and equestrian therapy, respite care and regional centers and all this stuff. And, I understand what parents are going to go through or have already gone through, so I'm able to really relate to them, and that's why it's something that's been really near and dear to my heart. And then when my wife was finally diagnosed with cancer, it made things even more challenging. I remember sitting in a Laker game, and in the middle of the game, she turned to me, and she had a lump, and it was painful. And we went to the doctor, and it turned out to be thyroid cancer, but not papillary anaplastic. It was kind of a weird type of cancer that required a lot of research and many trials. And after 3 years of battling with it, and countless doctors and hospitals and surgeries and chemo, my first wife of 16 years passed away. I felt helpless. I was there day and night with her. I knew I wasn't going to be able to save her, and and she was ill. Our relationship changed. I became her caregiver. So not only was I caring for a child who had special needs, I was also caring for my wife at the same time, and you can imagine the stress that would take.
Oh my goodness, yes.
So, this whole experience, has really given me the education to offer advice on topics and that really need to be addressed. And my life evolved, and so did my practice. I really enjoy helping people to solve the problems and help them navigate this very complex system. And as I already mentioned, I truly can relate to parents, the stress that it causes, and all of the financial burdens, having to race around from IEPs to IEPs to all these different things, that there's just not enough time in the day to think about planning for today, let alone think about the challenges that we need to face later on, and planning for those things as well. And to answer your second question, what can be accomplished with special needs planning? There's so many things that special needs planning accomplishes. First of all, it's ensuring that we provide financial security, whether it's with your own assets or whether it's finding a way to fund a lifetime of support and care. The nice thing about our practice is we do take a holistic approach, because not only am I an attorney, I'm able to look at the financial aspects as well, because I'm also a financial planner as well. So we can integrate all of the financial aspects into the legal plan and make sure that we have a comprehensive plan. We're also able to, make sure we've chosen the right guardians. We can, provide leverage for any means-tested public benefits, which for those that don't know what that means, basically there's certain benefits that your child might be entitled to, such as SSI or Medi-Cal. And so we're able to leverage those benefits, making sure we have the proper team in place to provide a lifetime of management, provide for appropriate housing, and really make sure that we have an ongoing system for advocacy. And that's one of the biggest issues, is most time when people plan, they don't plan for, they're only looking at the short term. They don't realize that they need to design a plan that's going to need to work for the next 30 to 50 years. And so a lot of times the planning that a lot of people do fails because they haven't taken into account what kind of advocacy is going to need to take place and how much the financial burden is going to be for the next 30 to 50 years. Those are some of the things. There's a whole other list I can go through: planning for caregiving needs, coordinating extended families planning, protecting assets from predators, preserving assets for other heirs. There's just so many different things. And the biggest thing is ensuring that, if your child isn't here, that they're going to have the necessary resources, including government benefits such as SSI and Medi-Cal, possibly life insurance to fund their plan, and a system of advocacy.
Well, what about medical decisions? What are some of the things that you must do to continue to be able to make medical decisions for your child with special needs once they become 18?
Well, that's a good question. Most people don't realize this, but when you turn 18, you are considered an adult, whether you're able to face the decisions of the world on your own or not. You're an adult. So whether you have a disability or not, you have to put in place a healthcare directive in order for somebody to make medical decisions if you're unable to. Now, for parents or loved ones who have a individual who has autism or any kind of disability, a lot of times they want to be able to continue advocating on their behalf and continue being able to make medical decisions for them. But the law says they're considered an adult. So that means that you're unable to make those decisions for them. You're unable in some cases to even speak with doctors or get confidential records due to medical privacy laws. So if your child does not have the legal ability to sign a healthcare directive, you have to go into court and establish what's called a conservatorship, or in this case, a limited conservatorship, that will allow you to take over and continue to manage their healthcare decisions. Also, it can allow you to basically look at 7 different powers, but they include the ability to sign contracts on your child's behalf, determine their residence, determine education, whether they can get married or have marital relations, are some of the things that also are granted in a limited conservatorship.
Can you also talk about something called a special needs trust that is used to protect assets for your child with special needs and disabilities?
I sure can. So, yes. A special needs trust, trust sounds like a big, scary word. A lot of people these days have a trust. And, a trust is just kind of like a box that holds assets. And you provide a system of management in that box. And you also figure out how you're going to fund that box and how you're going to provide advocacy ongoing. There's a special kind of trust, for a better word, that's called a special needs trust. It also goes sometimes by a supplemental needs trust. Doesn't matter what it's called. It's basically a trust that's designed in a way to protect government benefits that your child might be relying on, such as supplemental security income or Medi-Cal, because these programs have strict asset and income limitations. And if those limitations are exceeded, that's going to disqualify your child from benefits. So if you were to leave your child assets directly, and now they have assets that exceed the limits, which are currently $2,000, that can result in a loss of those benefits. Now, a lot of times, SSI doesn't provide for a whole lot. SSI in California provides for approximately $900 a month. I don't think anybody can live off of $900 a month in California.
Yeah, that would be pretty tough.
Yeah. So the question is, if you're going to be able to leave enough assets to your child, why do we really care about the SSI? The reason is that if you have $1 of SSI, you automatically qualify for Medi-Cal. And Medi-Cal, in some cases, can provide a whole host of medical care, and in some cases be the only form of medical insurance that your child is relying upon. And losing the Medi-Cal can be even more critical than losing their SSI. So those are the reasons why, even if you're able to leave significant assets, sometimes you want to protect those government benefits. And so it's a special kind of trust that's authorized by law that if the assets go into this trust, that those assets are not considered their assets, and there's no loss of benefits, but the assets in the trust can be used for their benefit and for whatever needs that they require. And also, as I've already mentioned, it provides for a ongoing system of advocacy. Because again, figure if your child's 20 or 30 years old, that you may need to have this in place for the next 50, 60 years. So you need to have a system of advocacy in place to continue the great job that you're doing as a parent for your child.
What about something called an ABLE account, ABLE, an ABLE account that has recently become available in California? I know it was available in other states, but it's now available in California. Can you talk about that a little bit as well, please?
Sure. Yeah. ABLE stands for the Stephen Beck Achieving a Better Life Experience Act, and what it does is that it allows a semi-independent adult who has disabilities, or even a parent or guardian on their behalf, to be able to save a certain amount of money without jeopardizing their government benefits. And currently, you can put away $15,000 a year up to $100,000 in it without affecting SSI, and up to whatever the state maximum is without affecting Medi-Cal. So you can go over $100,000, you'll have a loss of SSI, but you won't lose Medi-Cal with assets in an ABLE account. In addition, the money that goes in there grows inside the account, tax deferred, and as long as the money comes out for qualified expenses, then those assets are also tax free when they come out. Basic living expenses and other expenses, which are things like education, housing, transportation, employment training and support, health prevention, wellness, financial management, administrative services, of course, legal fees and funeral and burial expenses are all included under those basic living expenses. And also, if you're working, you can put away some additional of your own income into the ABLE account. We actually, when I do presentations, we actually spend 20, 30 minutes talking about all the rules about ABLE accounts, because there's quite a few rules. But for those of you that are familiar with 529 plans, the 529 educational plans, ABLE accounts work very similarly to the way a 529 plan works.
Well, you mentioned something that was very interesting, that if you go over the $100,000 mark in that account, you might lose SSI, but not your Medi-Cal. But I thought you had to have SSI in order to qualify for Medi-Cal. But is that not necessarily the case?
Oh, that's a really good question. My understanding is that in an ABLE account, if you do go over $100,000, let's say your account goes, to $102,000, your SSI will be suspended until the account drops below $100,000. However, your Medi-Cal will not be lost.
Interesting. Very interesting. So then what is the best way for someone to financially plan to provide for a lifetime of care for their special needs child? And I'm going to ask a second question because I think they're related. I think they go well together. What is the biggest hurdle that families face in establishing that special needs plan for their child or their loved one?
Well, when you're looking at a financial plan, the first thing you need to do is sit down and try to assess what are the costs of care going to be. Is your child going to require housing, someone to supervise them, a care manager, medical care, et cetera? And are these things that are going to be ongoing? Are they going to be short-term? Are they going to last for their lifetime? So you can kind of map out and determine what is the lifetime cost going to be to cover care for the next 50 to 75 years or more. And if when you're looking at, what are your sources of income and assets, if there's a shortfall there where you don't have enough assets to cover all these expenses, then we look at, options that can be put in place, many different financial options to be able to build up wealth and create your own, private retirement plans, a private pension where money can come out tax-free, for example, and also looking at, if you should pass away, that there is enough assets, potentially through the death benefit of a life insurance policy that can be structured in a very specific way and structured inside coordinated with the special needs trust so that there's no loss of any government benefits. I think the biggest hurdle that families face is really just not knowing where to start and who to talk to. Do I talk to, my financial advisor? Do I talk to my estate planning attorney? Am I going to be talking to the right estate planning attorney, somebody who does understand this area and has compassion and has the knowledge to understand the best way to, again, structure a plan that's really going to work? Because that's the biggest problem that I see, is that people design plans that they just don't work the way they're designed to. And and also I also see a lot of times that if you have separate advisors, that a lot of times one advisor isn't talking to the other, and there isn't a cohesive, coordinated plan. And that's one of the real great benefits of working with us, is that we do have expertise in so many different areas that we're able to put together the very best plan for you, both legally and financially, so that's well coordinated together.
What about the people who think that they can do this on their own? Is this something that they can do on their own? And what are some of the common misconceptions that they might have in their mind about special needs attorneys that might prompt them to say, you know what, I'm just going to take care of this by myself?
Well, as you can probably, see from, just this very short podcast, that this area is very complicated, and this is definitely not something you should try to do on your own with a fill-in-the-blank form. Or, it is true, I will tell you, that a special needs trust is by statute. It's called a D4C trust, or a third-party special needs trust. If you wanted to, you could go to the, I think it's in the Internal Revenue Code. You could actually copy and paste the statute, and you've got a special needs trust, but you really don't have much more than that. And, sometimes that's what individuals and sometimes even unexperienced attorneys do, is they just take a form that really does not, it's kind of cookie cutter. It doesn't really take into account designing it, again, in a way that's going to work for the next 50 to 75 years. And it doesn't look at various things like, what is going to be the appropriate housing, and what kind of care am I okay with, and what kind of activities do I want to get my child involved with, and all kinds of things are addressed in there. It becomes, about a 50-page document in some cases or more. And a lot of times we're designing this as a separate, standalone third-party trust, which means that it exists today such that other family members can leave assets to it. So if you've got grandparents, if you've got aunts or uncles, you've got other individuals who might leave assets, which again will result in a loss of benefits, that the trust exists now. So we just tell them, change your plan, change your beneficiaries, and leave it to the special needs trust instead. Did you ask me another question? I can't remember what the other question was.
No, some of the common misconceptions about special needs attorneys. That this is obviously sounds like something that someone would be better off having an expert help them do. But you can kind of fold that into the next question I was going to ask you. If there are misconceptions that people have in their mind about special needs attorneys, and also, what are some of the important things that they should consider when evaluating hiring an attorney/financial planner to help them with special needs planning?
You're right. The questions do go together, because, the misconceptions, first of all, are that any estate planning attorney who calls himself an estate planning attorney can properly design and prepare a special needs or supplemental needs trust. So you do want to make sure that the attorney that you're working with has done quite a few of these and does have the proper knowledge and experience to not only design it, but to understand how to properly administer and manage that trust. And you're going to want to look at things, like, what kind of experience do they have in drafting these trusts? Do they, actually understand the challenges that the parents have gone through or will go through, and, enough compassion to understand how this trust needs to be designed so that it really does support their child and provide that continuing advocacy that you're providing for your child yourself. Other things to look at is, are they a certified specialist? Do they have reviews from other families or other attorneys? Are they recognized as a super lawyer, which means that they are in the top 5% of all attorneys in California, for example? And if they're out in another state, same thing as well, that they're in the top 5% in whatever state you're looking at. And so those are some of the things I would be considering as well.
So this is all fantastic information and is applicable, as you say, in whatever state you happen to live in. You yourself, though, practice in California. And tell me, how can our listeners reach you if they have questions or they want to know more?
Well, you can call our office at 818-905-6088. You can also take a look at our website at EST, that's EST like a state, PLAN.com. And by the way, there is a great guide on our website as well that you can download that talks more about special needs planning. So I'd encourage you to go there and download our guide. And if you do call our office and mention that you heard us on this podcast, then we will waive any consultation fee that we would normally charge. So we'll sit down with you at no charge, just by having gotten a little bit of education and taken the time to listen all the way to the end of this podcast.
Well, that's good, because it does help to have a little bit of education and be able to go in and at least begin the conversation with the right questions. So thank you for doing that, Gerry, and also thank you so much for your time and the very helpful information that you shared with us today.
Oh, my pleasure, and thank you for as well, Gilda, for this honor of being able to do this, and as I mentioned, also to hopefully this helps a lot of people out there, because so many people have a loved one these days who has a disability and just doesn't even know where to begin starting to put in place a plan. And like I said before, the challenge is, you're so busy trying to deal with everything today, racing around from appointment to appointment, that you really don't stop to sit and think about, well, what do I need to do and plan for tomorrow? And, the old adage, people don't fail to plan, they just plan to fail. So don't plan to fail. Make sure that you do get this planning in place as early as possible, and that everything is done the right way, and that you have the peace of mind knowing that if something should happen, everything's going to be taken care of.
And that's great advice, Gerry, and thank you again. I also want to thank our listeners for spending a part of their day with us. I'm Gilda Evans, reminding you to take care of yourself and that special person in your life.